Testing, testing.
Okay. I was debating whether or not I'd be
All right.
able to take a show.
Good morning. Welcome to the Public Service Commission's administrative meeting for May 1st, 2024. Before we move to the minutes, I want to recognize the fact that we now have a new general counsel representing the Public Service Commission. And he's in the very back row there. Miles Mitchell this is his first official day as general counsel for the Public Service Commission, and we look forward to his wise advice, as we did from Bob for many years. And so Bob's off to a well-earned retirement from his long service to the state, both as general counsel and And as some people know, he was actually I don't know, the original, but one of the sort of founding directors of the Consumer Protection Division at the Attorney General's office. He did that under Attorney General Sachs before he came
Wow.
to us. So we thank Bob for his longtime service, and we look forward to working with Miles on all the issues that come before us.
Mr. Chairman, can I just say something quickly? Of course, you have very large shoes to fill, and hopefully you will have the similar tendency for amusing facial expressions during bizarre arguments. So I'll be looking forward to that. Thank you, Mr. Chairman.
And so so the first item is to approve the minutes from our meeting of April 17th, 2024. Commissioner Sushman.
And then I just also want to say, welcome, Miles, and I look forward to your counsel. You've provided us with really wise counsel in the almost a year since I've been here, and I'm very excited to be working with you going forward.
Commissioner Barve.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. And with that, Mr. Secretary.
Good morning, Mr. Chair. At the outset, wanted to note that item 9 on the administrative agenda will be deferred to the May 8, 2024 administrative meeting. There are 6 items on today's consent agenda. Item number 1 consists of revised tariff pages from AT&T Corp. Reflecting an internal corporate restructuring. Item number 2 and 3 are both applications for licenses to supply, respectively, electricity and gas services in Maryland from 3 Point Energy LLC. Item number 4 is a request from Elite Energy Clean Energy for certification of a renewable energy facility. Item number 5 consists of revised tariff pages from Verizon Maryland LLC. And finally, item number 6 is a request from Alpha Structure EMTOC LLC for approval to construct a solar generator in Rockville, Maryland.
Okay, so regarding item 1, I move that we accept the tariff provisions for filing with an effective date of May 1, 2024. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. Regarding item 2, I move that we grant the company a license to operate as an electricity supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff. Second, direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff 30 days prior to the utilization of the materials in Maryland. And third, direct the company to file notice with the Commission within 30 days of any changes to the information in the application. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. Regarding item 3, I move that we grant the company a license to operate as a natural gas supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff. Direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff 30 days prior to the utilization of the materials in Maryland. And 3, direct the company to file notice with the Commission within 30 days of any changes to the information in the application. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. Regarding item 4, I move that we approve the application and issue a Renewable Energy Facility ID certification number. Second, direct the applicant to establish a REC account with PJM GATS within 30 days of certification. And third, direct the applicant to notify the Commission within 30 days if any of the information on which the application is based has changed. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. Regarding item 5, I move that we accept the tariff provisions for filing with an effective date of May 9, 2024. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. And regarding item 6, I move that we approve the application of Alpha Structure EMTOC LLC. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
And item number 7 for the administrative agenda is the 2023 unaccounted for water surcharge reconciliation for Pinto and Highland Estates from Maryland Water Service, Inc.
Good morning, Mr. Chair and Commissioners. Lucy Shea on behalf of staff, together with Barbara Weber of the Engineering Division. Maryland Water Service, or MWS, filed its 2023 unaccounted for water UFW surcharge reconciliation for Pinto and Highland Estates customers, addressing Pinto Water Systems overcollection and Highland Estates Water Systems undercollection of water costs in 2023. Pinto's adjusted UFW percentage was equivalent to 3%, and Highland Estates was equivalent to 25%. The company did not meet its goal of keeping the annual adjusted UFW percentage at or below 20% between January and August of 2023 for the Highland Estates system. However, following the completion of a major water main replacement project in September of 23, the company attained a UFW percentage below 20% in each month between September and December of 2023. Maryland Water Service proposes to issue a $16.67 one-time credit to each Pinto customer for its over-recovery of water costs in 2023, and to implement a 12-month surcharge of $5.15 per 1,000 gallons to Highland Estates customers for its under-recovery of water costs in 2023. In the stipulation and settlement agreement in case 9212, the parties agreed that for any future year in which gross UFW amounts exceed 20%, the company will not be entitled to recover automatically. Staff concludes that although the company did not meet its UFW percentage goal in the Highland Estates water system, the company made reasonable attempts to locate and mitigate leaks in 2023. Pursuant to the stipulation and settlement agreement, the company followed its prescribed procedures to reconcile estimated UFW losses. Staff recommends that the Commission accept Maryland Water Service's filing and tariff revisions, and also recommends that the Commission direct Maryland Water Service to submit a report to the Commission containing detailed information on actions taken by Maryland Water Service to identify, quantify, and reduce the levels of Highland Estates UFW, and on the subsequent results achieved by those corrective actions. Thank you, and Barbara Weber of the Engineering Division and I are available for questions.
So, questions for staff. Commissioner Barve.
Yeah, and I think I know the answer to this, but I just want you to confirm it. I presume that the one-time credit of $16.67 wasn't done volumetrically because it just wouldn't make that much of a difference, and it's the simplest way to apply it.
Actually, I'm not sure which way it goes, but I know that that Highlands Estates has to be volumetric, and Pinto
Doesn't need to be?
doesn't need to be. Or maybe, do you, Dave?
You know, maybe I should direct this at council for...
Yeah, it's actually, there's a reason for it, but I'm not
Sure.
clear.
I guess, all right, I mean, just looking at it from an accounting standpoint, I suppose that since half of the charges were fixed and half were volumetric, it would just be too involved to parse out what the credit would be to each of the customers. Is that the reason?
I think that's correct, Commissioner. I think there's also, in terms of being able to provide the refund as quickly as possible, just doing it as a lump sum amount, in 1 month's billing cycle is the simplest way to do it. I will add that historically, this is how Pinto has done it ever since I've been involved with the company, I think before I was representing them as well.
Okay, thank you, Mr. Chairman.
Oh, Mr. Commissioner, I have it, Barve. Pinto's tariff requires that any UFW surcharge for customers be divided I folded it, so I can't read it. Okay. Pinto's tariff requires that any UFW surcharge for customers be divided evenly between a fixed charge and a volumetric charge. However, because the company determined that it over-recovered its water costs from Pinto customers, it recommends the Commission authorize a one-time credit to each Pinto customer. Pinto's tariff does not specifically address the manner by which over-recoveries are to be refunded. Getting better?
Yeah, no, I get it. I doubt it would make much of a difference if it were done more precisely. So simple is best in this case.
Okay, so anything else from the company?
Thank you, Chair Hoover, Commissioners. David Bugelmans on behalf of Maryland Water Service. I have nothing to add to staff's presentation, but happy to answer any additional questions from the bench.
Commissioner Sushman?
Okay, good morning, Mr. Bugelmans.
Good morning.
Could you explain to me how it was that you were able to over-recover from Pinto customers, notwithstanding the fact that you had water losses? I'm trying to understand how that works.
Yeah. This is a true-up mechanism that's designed to account for what's called unaccounted for water. Basically, every water system in the country, there's leaks in the piping. So there's always a certain amount of water loss. What Maryland Water Service tariff allows is for the company to collect a 15% premium on top of what it pays municipal sources for its water supply. Both of these systems, Pinto and Highland Estates, they purchase the water from municipal sources. So they collect a 15% premium on what they pay. And then at the end of the year, through this true-up mechanism, if they have over-recovered because the UFW level for the system was less than 15%,
Okay.
then there's a refund, and if it's above it, then they need to collect the balance through the surcharge mechanism.
Okay, and then when customers are either given a check or are charged additional, does the company explain why that is?
That's correct, Commissioner. There is a notice requirement. We attach the proposed notices to our filing for this true-up, and that's how we've done it ever since I've been involved with this. So there is a required notice that explains what's going on and why there's a change in the surcharge.
Okay, thank you.
Okay, this actually may be a question more for the engineering division, but I mean, I know historically Highland companies had kind of repeated problems with the leak in their system. So is it staff's view that the company, was diligent in detecting the leak and then making the fix to the system?
Barb Weber, staff. Yes, they've been involved in a main replacement project, and phase 1 was completed in September. And since then, in the Highland system, they appear to have gotten their leaks very much under control, gotten it down to a minimum.
And you're comfortable with the, I guess, monitoring part that they do on that system? Because I know this leak problem is, and a lot of it has to do with where the system is and the area where the pipes are and things like that. But you're confident that they're being diligent and looking at the system to make sure that the leaks are plugged.
Yeah, it's tricky, but yeah, the staff is really vigilant with watching the meter discrepancies in the meter readings, and they also have their own acoustic equipment, and they're regularly going out and looking for leaks. And when they see the discrepancy get above a certain level, then they step up the leak detection.
Okay.
Yeah.
All right. So with that, I move that we authorize the company to issue a one-time credit of $16.67 to each Pinto customer and implement a 12-month volumetric charge of $5.15 per 1,000 gallons for each Highland Estates customer by accepting the company's proposed Pinto and Highland Estates tariff revisions effective May 1, 2024. And secondly, direct the company to submit a report to the Commission containing detailed information of actions taken by the company to identify, quantify, and reduce the levels of Highland Estates UFW and on subsequent results achieved for those corrective actions by the calendar year 2024. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
Mr. Chair, item number 8 consists of revised tariff pages from Washington Gas Light Company.
morning, Chair and Commissioners. Evan Thomas on behalf of staff. On April 10th, 2024, Washington Gas Light Company filed revised tariff pages in compliance with Commission Order number 9043, issued on December 14th, 2023, and Commission Order 91079, issued on March 28th, 2024, both in case 9704, which was Washington Gas's base distribution rate case. These orders authorized Washington Gas to adjust its natural gas distribution rates to collect an additional $12,579,764 in revenue. And the filing here establishes new distribution rates that will allow the company to collect this additional revenue. Staff has reviewed the filing and the rates and conclude that the proposed rates follow the orders and do result in an additional collection of $12,579,764. The average bill increase for residential customers is estimated to be about 0.5%, and for commercial and industrial customers, the bill increases are estimated to range from about 0.5% to 1.8%. Staff recommends the Commission accept the tariff pages for filing with an effective date of May 1st, 2024, and I'm available for any questions.
So, any questions for staff? Okay.
Morning, Mr. Chair and Commissioners. Spencer Nichols on behalf of Washington Gas. We have no comments beyond what we submitted in our written filings. We appreciate staff's review.
Okay. So with that, I move we accept the tariff provisions for filing with an effective date of May 1, 2024. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
Mr. Chair, item number 10 is a request from TIMO Renewables LLC for approval of a decommissioning plan.
Morning, Chair Hoover, Commissioners, Roger Austin on behalf of staff. On August 14th, 2023, the Commission issued an order granting TIMO Renewables LLC a certificate of public convenience and necessity to construct a 9.9 megawatt solar generating station in Wycomico County. The Department of Natural Resources Power Plant Research Programs License Condition 34 required TIMO to provide the Commission and PPRP with a decommissioning plan for review and approval prior to the start of construction. The plan shall address how project components that are subject to decommissioning will be removed and or recycled. Condition 34 also requires TIMO to secure a funding mechanism that covers the cost of implemented decommissioning plan. This is to ensure that the state and or county are not responsible for decommissioning cost at the end of the project's useful life or in the event it is abandoned. Additionally, the decommissioning cost estimate and the funding mechanism are to be updated every 5 years over the life of the project to account for inflation or other necessary changes. Staff has reviewed TIMO's decommissioning plan and finds that the plan adequately addresses the requirements of PPRP Condition 34. TIMO has estimated the net decommissioning cost to be $320,695. TIMO has proposed to post a surety bond in the amount of $320,695. Staff concludes that TIMO's decommissioning plan meets the requirements of PPRP Condition 34 in the CPCN for the retirement of its solar generation station. Staff recommends that the Commission approve TIMO's proposed decommissioning plan and direct the company to provide documentary evidence of having acquired a surety bond for the amount of $320,695 prior to the start of construction.
So, power plants on board with this?
Yes, Your Honor. Sandra McLemore on behalf of the Power Plant Research Program. We filed comments on Friday indicating that we had no objections.
Any questions for either staff or PPRP? All right, Mr.
Thank you, Chair Hoover, Commissioners. David Bugelmans, this time on behalf of TMO Renewables. I have nothing to add to this one as well, but happy to answer any questions.
So, any questions for? All right. Nope. Seeing none, I move that we approve the company's decommissioning plan and direct the company to provide documentary evidence of having acquired a surety bond for the amount of $320,695 prior to the start of construction. Commissioner Sushman.
Aye.
Commissioner Barvet.
Aye.
Commissioner Richard. Or Commissioner O'Donnell.
Aye.
I vote aye.
Mr. Chair, item number 11 is the STRIDE 2023 Annual Report and Reconciliation Factor Filing from Elkton Gas Company.
Good morning, Chair, Commissioners. Michael Dean on behalf of staff. Item 3 is the annual 2023 Strategic Infrastructure Development and Enhancement, or STRIDE, status report filed by the Elkton Gas Company under Public Utilities Section 4-210, known as the STRIDE statute. The gas company may adopt a plan with approval of the Commission that provides for the replacement of certain infrastructure over a 5-year period with a recovery of some costs through a surcharge that is limited by statute to be no more than $2 per month for residential customers. Order number 89931 of August 20, 2024, which approved the company's initial STRIDE plan, requires the company to file its project list for the coming year and also a status report on completed projects annually. The staff comments provide its analysis of the Elkton Gas status report, details review of the completed work, review of project costs, and of the surcharge calculations. Staff determined that all calculations were performed correctly and agrees that the STRIDE surcharges for all customer classes are capped at the limit set per the statute. Under the settlement from case number 9660, the STRIDE surcharges are to remain in effect until the end of the next rate case, which is case number 9722. Staff recommends that the Commission accept Elkton Gas's final report and accept for filing the company's proposed surcharges through the end of its current base rate case.
So, any questions for staff?
Good morning, Mr. Chairman. Brian Quinn on behalf of Elkton Gas. Appreciate staff's buck sheet and obviously agree with their recommendation. Here to answer any questions you may have.
Any questions for Elkton? All right. With that, I move we accept the company's final report and accept for filing the company's proposed surcharges until the end of its current base rate case. Commissioner Sushman.
Aye.
Commissioner Barvet.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
Mr. Chair, item number 12 is the 2023 STRIDE filing from Baltimore Gas and Electric Company.
Michael Dean again on behalf of staff. Item 12 is the Baltimore Gas Electric Company 2023 Strategic Infrastructure and Development and Enhancement Program. Project cost variance information filing and the STRIDE reconciliation report for the final year of its STRIDE program. Beginning with 2024, STRIDE work will be included as part of the company's multi-year rate plan and collected through base rates. The applicable law for this item is the same as the previous item. The BGE filing reports the 2023 work that was completed, the costs, and a true-up of funds collected under the surcharge. Staff has reviewed the filing as discussed in the staff comments, noted projects with large cost variances, and determined that costs and funds collected under the surcharge were correctly calculated. The company proposed that interest and carrying charges be refunded back to customers using a one-time bill credit in May 2024, a proposal which staff supports. The following may be a revision to the staff comments. Staff recommends that the Commission accept the 2023 STRIDE true-up report and authorize the company to refund interest and carrying charges owed to customers. The Office of People's Counsel also filed comments in mail log number 309322 recommending essentially that the commission direct the company to remove the Stride Rider 16 from its tariff and to include a notice on every customer monthly bill informing customers that the cost of the Stride eligible work is being recovered on an accelerated basis.
So, any questions for staff? Oh, Commissioner Sutton.
Mr. Dean, before you leave, so you noted the People's Council's recommendations. Does staff have a position on their proposals?
Good morning, Mr. Chair and Commissioners. Pam Coates on behalf of staff. Staff does not take a position at all on that.
All right, so, but just so we clear this, when you say no position, this means you're not opposed to it, but you don't support it, correct?
That's exactly correct.
Okay,
Thank you for that clarification, Mr. Chair.
okay, all right.
Thank you, Chair Hoover. Good morning, Commissioners. I'm Michael Sammartino on behalf of the Office of People's Counsel. I don't have much to add to our written comments, so I'll keep my remarks relatively brief this morning. It may be intuitive to us in the utility regulatory sphere that any capital investment costs for gas infrastructure that are no longer recovered through the STRIDE statute are going to be recovered through base rates, but it's not to the vast majority of BGE's customers. And our recommendations regarding the removal of the Rider 16 language, as well as the customer notice on bills, is to ensure that customers are made fully aware that BGE is still pursuing STRIDE-eligible Operation Pipeline investments, albeit through its MRP. Our position is that this would limit any confusion about the status of the company's involvement and participation in STRIDE currently and into the future. We'd also like to note there was, in staff's buck sheet, there was a recommendation for guidance on an acceptability range for project variances. We don't think that's properly considered in this proceeding. We appreciate the spirit and intent of having that discussion, but just want to make clear that I think there's a better forum and a better proceeding to consider that issue. With that, I appreciate your time and consideration of our comments, and I'm available for any additional questions you may have.
So, any questions for OPC? All right, so, Mr. Herson.
Thank you, Chair Hoover. Commissioners, good morning. Daniel Herson for Baltimore Gas and Electric. I also have with me today Kevin Nelson, who's our Senior Manager in Project Management, Rachel Weaver, who's our Manager of Projects Execution, and John Frayne, who is our Director of Regulatory Strategy and Revenue Policy. As always, I want to thank staff and OPC for their analyses. And I also just want to take a minute to say, since this is really the last filing under our STRIDE 2 plan, and really for the last 10 years, I just want to thank staff, the Commission, Engineering Division, OPC for all the collaboration over the past 10 years. You know, we haven't always agreed, but we've worked well together, been through a lot of filings, a lot of work groups. I've been the attorney on this matter since the beginning in 2013, and I think I can say, you know, for the company, and certainly for myself, that, you know, we appreciate the level of professionalism and collegiality we've had with everybody over the past 10 years. We've gotten a lot of work done under the STRIDE cost recovery mechanism, lots of miles of main replaced, thousands of services replaced, and I believe in a more environmentally sound gas system, including removal of a lot of low pressures. I just wanted to thank everybody for their work over the past decade. Regarding this particular filing, we're available for questions after I make some responses to OPC and staff's proposals. Regarding the elimination of Rider 16, we actually agree that Rider 16 should be removed from the gas tariff, but our view is it shouldn't be removed immediately. We're going to have that refund to customers, assuming the Commission approves it today, in May, but the reality is a fair number of customers are probably going to see a refund that straddles the May-June timeframe, because billing, the way billing cycles work and the way they go out, they don't always go out at the same time. There's also situations where you might have a rebill for a mistake. You might have a situation where a customer wants to refer to their bill a month or two later, Maybe they didn't look at it immediately. So you could have late bills, that sort of thing. So we believe that the more prudent approach is to keep Rider 16 in place for at least a little bit longer. You know, our suggestion is we could have it removed from the gas tariff when we come in to make our next general gas tariff filing. So I don't know exactly when that would be, but I think we're probably talking about 3 to 6 months timeline, something like that. And also, you know, Rider 16, as it is right now, says that the surcharge is not to exceed $0.00. That was language that was agreed upon between the parties as part of BG's latest MYP. So we just believe it should continue to be available to customers, you know, who may have questions about the stride charge on their bill for a reasonable period of time. But, you know, eventually it can come off. On the stride message on the bill, you know, while BG supports customer transparency, we think keeping that message on the bills through 2026, basically 36 months, is what OPC is recommending, you know, through the duration of the MYP2, is going to have an unintended effect of potentially confusing customers more than we think it's going to help. We continue to be supportive of placing the message on bills, but only until we get done with that refund process, which again, mostly happening in May spill over into June. So our suggestion is, you know, we keep it on there, but only until that process is over. So again, May, June time period, something like that. You know, there are other reasons, though, that it should probably come off. I can tell you that real estate on the bill, like actual words and lines and characters, matters. I didn't appreciate that until I came to work at the utility. I used to think, oh, what's another line on the bill? Then I learned that, you know, the bills are automated. There's expensive, complicated systems involved in that process. When you go beyond a certain number of lines or a certain number of characters, you can incur a lot of additional costs, including if it ends up going into extra pages. So, you know, we think that keeping that on the bill for multiple months potentially could keep other important messages off the bill. Or if they have to go on the bill, that's going to end up costing a lot more money for BG to put those bills out. So we just don't think that the value is really there in having that message. I also think it's kind of inconsistent. If you're going to take away Rider 16 that's talking about the stride surcharge, then why are we having a bill message on there that's continuing to talk about what was the stride surcharge? Because these projects are now being done in the context of the MYP. They're like any other gas project, really any other project that the commission has approved spending for in the MYP. They're not being, the cost of those projects not being recovered quicker than other projects in the MYP. It's basically they're all being treated the same in the MYP. So why single out these gas projects just because at one point in time initial cost recovery was through the stride surcharge and now it's through MYP rates. The other thing is I'll remind the commission and the parties that historically cost recovery for the gas infrastructure projects has happened both through the stride surcharge at first, but also through base rates anyway. So the past 10 years when we've had the stride surcharge in place, cost recovery started under the surcharge, but when we reset those rates in a rate case, those projects got moved into base rates, and then whatever was continued on the surcharge after the reset was new expenses that were related to new projects. Now what we have after the commission approved the shift into the MYP is you have new project costs being recovered through MYP rates as opposed to the surcharge. So again, I think there's a transition period here. We're not trying to hide anything from customers, but we just think once you get past that May, June time period, you're going to have cause more confusion by continuing to have that bill message there. Happy to take any questions that the commission may have this morning. Thank you.
So, questions for the company? Commissioner Sussman.
I guess the issue is for the customer that doesn't do this for a living. I mean, we all do this, and so when we pick up a bill, presumably we understand what the bill is trying to convey, although not always. But assuming that you know you're dealing with a for lack of a better term, a sophisticated customer, but only sophisticated in the sense that this is what we do for a living. We can understand when a line on a bill disappears. We understand what that means. But I think we need to think about what the customer sees and what the customer is used to seeing, and that's really what I'm mostly interested in. And it may be that taking out that message language for 2 years doesn't make a whole lot of sense and could cause confusion. But at least in that sort of interim period, it just seems to me that it would be in the utilities' interest to make sure that the customer understands what's in the bill and doesn't call you and complain or complain to us. And so I'm not sure that a month or two is and for a customer that is very busy it's going to work necessarily. Taking it to June may not be enough. I mean, maybe it doesn't need to be till 2026, but maybe there's a way for the company and People's Council to talk about what makes the most sense so that customers are not confused. They're going to be paying a bill, but things are going to be changing, and maybe a month or two is just not enough time.
So thank you. I appreciate those comments, and I think we're probably more aligned than maybe initially it looks. I agree that customers need to know what's going on with the change. They haven't seen that line item on their bills since December, I think. I checked my gas bill the other day. I didn't see it on there currently. But yeah, there's a point though where I think the value add ends, and maybe it's not immediate. Maybe it's more gradual. But the question is how long? I think once you start getting past that June period into the late summer, people are going to say, well, what does this mean? I haven't seen that surcharge on my bill in quite some time. I don't know what they're talking about here. And then you start to get calls and questions to us and maybe to the commission or the Consumer Affairs Division, I don't know, but then it's causing more confusion than good. So yeah, maybe there's a sweet spot somewhere in there. I think from our perspective, if you're going to take it past the May 2024 timeframe, then we should probably at least eliminate that last line from the message, which talks about May 2024 receiving a refund, because if you're in July or August and you're getting a bill message about May 2024, that's not going to make a ton of sense in our view. So we're open to a reasonable period of time, but we don't think that having it in there for 3 years makes a whole lot of sense.
So what's the certainty of this gas filing that you're talked about at the beginning of your comments?
The next general gas tariff filing?
Mm-hmm.
Yeah, let me ask if John Frayne can come up and maybe address that. I don't have a specific item in mind as I stand here right now, Chair Hoover, but I do know we make pretty routine filings, so maybe John has an idea.
I'm John Frayne, and I don't recall off the top of my head when the next gas tariff filing would be. It would be, within a few months, at the very least, probably sometime, later this summer or early fall, but I can't give you an exact date right now.
Okay.
We could certainly commit to, making a filing in a certain time frame if that's something that the commission, wishes to make sure that it gets made in a certain time frame.
Okay. All right, that's a possibility.
Mike Dean on behalf of staff again. One aspect of the proposed Office of People's Counsel emphasis on the notice on bills is that the recovery is accelerated. It used to be accelerated because it was being collected between rate cases, but with the MYP, I'm not sure that the use of the word accelerated would be appropriate anymore, and it actually would cause more customer confusion because it's no longer accelerated.
And actually, for Mr. Herson, just so I nail this down, this transition period you talked about what's the certainty about when you think that'll be finished?
In terms of when the refund will
Right,
be
yeah. Mhm.
provided, like I said, I think the majority is going to be May, but we have 700,000 gas customers, so inevitably some of that's going to go into June. Beyond June, it's going to be a very small number of
Okay.
customers. So yeah, I think by the end of July we're going to be done with that process.
Okay.
And just real quick, Chair Hoover, I want to just, I had tried to allude to it before, maybe not artfully, but what Mr. Dean was saying, we agree with. Everything is now in the MYP. That's recovered the way it's recovered in the MYP. Nothing's being treated differently than something else. So yes, when it was under stride, it was being recovered in a more accelerated fashion than compared to historic test year rate cases, but now it's just being recovered the way it is. So we wouldn't agree that it's accelerated, so to speak, but that's just a minor.
Okay. Okay, so OPC, why don't you react to the company's
Yeah,
partial offers here? So.
Yeah, thank you, Your Honor. Just on the use of the term accelerated, I think in stride context, acceleration refers to the rate of cost recovery relative to standard rate making. I don't think that's any different with the MRP. The MRP is just another form of accelerated cost recovery relative to standard rate making. So I think the term of accelerated is appropriate, even if all of the company's capital investments are currently recovered through a multi-year rate plan. As far as the shorter duration for the notice on customer bills, at the very least, we think that as long as the language of Rider 16 is still in the tariff, the notice about how costs are being recovered should be included on the bill. Commissioner Suchman, I appreciate your concern about making sure that the layperson and the customer is able to fully understand what it is exactly that they're paying for. And for the past 10 years, the visible surcharge on the gas bill has informed customers that a portion of what they're paying through rates is specifically related to gas infrastructure investments where accelerated recovery is granted through stride. The company is still continuing to make those investments, and at the very least, I think customers should be informed more than just a couple months about BGE continuing to pursue those investments just through a different cost recovery mechanism relative to stride.
So, given that, I mean, when you say continue the notice, are you talking about, 3 months from now, end of the year? I mean, give me some sense of what you would like.
I mean, our position and what we laid out in our comments is that as long as BGE is continuing to benefit from accelerated recovery through the multi-year rate plan, then the customers should be informed on their bill about how those costs are being recovered. With respect to the language about the refund being distributed for May, we've been in agreement about that might need to change after May. It wouldn't make any sense to have that, in June. But I think at the very least, if there's like a range of duration that you would consider, as long as there's tariff language specific to the stride statute, the customer notice should be on the bill.
Okay. All right, let me do this. I move that we note the filing and authorize the company to refund interest and carrying charges owed to customers, that the company will make a filing by June 30 to eliminate Rider 16, and that the notice on the bill will continue until the time that the company has formally withdrawn Rider 16. And then finally, I want to direct staff to meet with the relevant parties to propose the parameters of the variance test and the acceptable ranges. And Commissioner Suchman,
Aye.
Commissioner Barve,
Aye.
Commissioner O'Donnell,
Aye.
I vote aye. And with that, we're adjourned.